Under the Fifth Amendment's Takings Clause, the government may not appropriate private property for public use without just compensation. Is it a taking if the government uses one private company's confidential information for another company's benefit? That's the question in Ruckelshaus versus Monsanto. The Federal Insecticide, Fungicide, and Rodenticide Act, or FIFRA, requires pesticides to be registered with the Environmental Protection Agency before being sold in the United States. The registration process requires manufacturers to submit research and test data to the agency. Initially, FIFRA prohibited disclosure of product formula information, but said nothing about other data. Congress amended FIFRA in 1972 to permit a manufacturer to designate portions of its data as trade secrets protected from use or disclosure. Congress amended FIFRA again in 1978, eliminating trade secret protection. Data submitted previously could be considered in evaluating another manufacturer's application regarding a similar chemical for 15 years after the original submission date, if the subsequent applicant compensated the original submitter. If the parties couldn't agree on compensation, either could initiate binding arbitration. After 15 years, the agency could consider any data without restrictions. Monsanto Co, a Missouri pesticide manufacturer, sued agency administrator William Ruckelshaus in federal district court, seeking injunctive and declaratory relief from FIFRA's data consideration and data disclosure provisions. Monsanto argued that the statute affected a taking of property without just compensation or a public purpose. The district court ruled for Monsanto. Ruckelshaus appealed to the Supreme Court.